Hi, and welcome everyone to Ask the Attorney. My name is Blair Clark, and with me, as always, is Mr. David Sobel. David, how are you doing this evening?
I'm doing great. You always call me Mr.
Mr. That's right. Because my mother taught me manners.
Oh, please. I'm not that much older than you, am I?
Oh, you're
anyway, okay, forget it. Forget it. We won't talk about it.
Moving on.
All right, Blair.
So David and I hop on every so often, and his excellent staff puts together some fantastic questions that people either call in or email in to his office. And the questions always have something to do with real estate, contracts, finance, estates, probate, etc. So David, for those who are watching, can you just briefly describe to us what exactly should our viewer reach out to you for? And also, how can they reach you? What number should they give you a call at?
Okay, so great question. You know, we're real estate and finance attorneys, Blair. We've been doing this program, you and I, for, believe it or not, I believe it's approaching several years now.
We're going on, we're near year 2.
Near year 2. Okay.
Near year 2, yep.
But for 32 years, so for 30 years before that, I know we're just talking about age. Age is just, by the way, energy. And anyway, so, but for those 30 years, I've been in the arenas of real estate and finance and law. And everything that we do at my law firm deals with real estate. It's kind of like the hub, and contracts, probate issues related to real estate, corporate formation relates to real estate, and also real estate investors. You name it, anything to do with real estate, we deal with it. And there's around, I think, 76 areas underneath the umbrella of real estate law. Mm-hmm. There's subcategories or subspecialties, and we pretty much handle all of them. So it's a boutique firm that handles real estate and financial issues. And the way that people can get in touch with us is to call 888-789-1715, or you can go to our website, which is called provenresource.com. And the reason why it's called that is we really try to be a proven resource for those people who are inquiring into their legal issues, whether they're residential, commercial, they concern vacant land or industrial property, or probate issues concerning real estate. That website has a whole host of content, plus all our videos that we provide to the viewing public and our friends. The one thing I want to share with you is that we really prefer that when people just give us a call, pick up the phone and call when you have an issue, and we'll make time for you. Okay. Right.
And if for some reason you're watching this video and you are not on YouTube, go ahead and check out David's YouTube channel. Again, just a plethora and a wealth of content. I've watched David's videos before to help answer my own questions rather than giving him a call. I just went and watched a video and just answered the question for me really quick, or gave me that piece of information that I needed. So if you go to YouTube and you just go to the search bar, just type in David Sobel Law, Proven Resource. Right. His channel will pop up. Make sure that you like and subscribe. Right.
There you go.
And then stay tuned for.
You're a big booster, aren't you?
Awesome.
Thank you, Blair.
Content. Yes. Yes. So David's questions or the questions for David put together by his staff. We have several this evening. We'll bring you the first one, and that comes to us from Frustrated in Fenton. These questions always come with such great alliteration. So Frustrated in Fenton writes in, I have a remodeling contract with a contractor. It has an arbitration clause. What does that mean to me if I have to sue them? From Frustrated in Fenton. And that's a good question. That's a clause that, when we first started using contractors, we didn't know what that meant either. So good question, Frustrated.
Right. So how about this? Arbitration in general is a format for parties who are disputing a contract or who have a financial dispute or any type of dispute. That forum is pretty much a faster, unfortunately, a little bit more expensive process to resolve a party's dispute. It's usually outside of the court jurisdiction, meaning you're not going to your district court or your circuit court to have a judge make a decision on whatever the issue might be. Mm-hmm. Instead, the parties are submitting themselves to more or less a private format for what we call dispute resolution, okay? And what happens is the same type of pleadings that an attorney would file in court, same type of complaint, same type of grievances that we would put in writing and submit to a court. We're going to use those same documents in the same type of format, interrogatories, discovery work, litigation processes, all that that we deal with when we go to court. We're now going to do it pretty much on a faster track with a private individual who actually is experienced in making decisions. They're called an arbitrator or a mediator. The arbitration can be binding or it doesn't have to be. But what it really does is it makes the resolution of a dispute a lot faster for people who are having issues, and you don't have to wait really for a court decision that could take anywhere from 12 months to 18 months in good times. Mm-hmm. Right now, as you know, we're dealing with a slowdown in the court system because of a pandemic. And so parties are not resolving their matters very fast in regular court. Some are taking up to 24 months to get resolved. I have cases that are now scheduled with a judge to pretty much adjudicate the case for like out by 36 months. So that's how long it's taking to get something done. There are rules and regulations in arbitration that have nothing to do with how the courts function, and the parties submit themselves to those rules as well. So it's just, think of it as a private process that, again, is going to be a faster process usually. You know, parties can agree on what they want to discuss with an arbitrator, what type of evidence can be submitted to the arbitrator. And most importantly, the parties have to pay the arbitrator, unlike court, where our tax dollars pay for, you know, the staff, the court staff, as well as a judge. Okay.
Okay. So is anyone, does anyone stand to benefit more, either the contractor or the, let's just say, homeowner here, mm-hmm. or, you know, whomever it is that hired them? Is it more in the contractor's favor? So outside of just obviously the time saved, mm-hmm. Because of the differences between an arbitrator or a judge, mm-hmm. Why would a contractor, outside of just this will get done faster? What would be the benefits of the contractor?
That happens to be it's a great question, Blair. So when I talked about the rules of arbitration, mm-hmm. there are different types of rules in arbitration that concern, let's say, builders. And usually a builders association might be the influencer on those rules and regulations, right? With contractors, depending on what type of contractor, you might have, you know, a different set of rules for that type of dispute. Home builders definitely have their own rules and regulations in arbitration code, okay, regulations. So can it be more beneficial to a contractor to use arbitration? Sometimes. I mean, you know, both parties have to actually agree to who they want to appoint as an arbitrator. However, let's pretend for a minute this is a building dispute between a builder and a homeowner. The rules of arbitration may say that the parties can only select from a certain group of arbitrators. And those arbitrators are usually attorneys who happen to deal in construction law. So who do you think, I mean, I'm not saying this happens all the time, but who do you think is using these construction law attorneys more often?
Right.
The builder is using these real estate attorneys. So it can be a little bit more, I mean, I hate to cast any dispersion on very good arbitrators, but I mean, if there's a problem or an issue, you can, the nice thing is after a decision is rendered, even if it's binding arbitration, it still has to, there is a input from the circuit court. It still has to be ratified and approved finally by a circuit court judge, okay, in order for that arbitration decision to be effective.
Okay.
So we just did I just did a probate arbitration. You know, we went through several months of dealing with the property's value and what the heirs of an estate were entitled to. We prevailed, which was nice, but then we had to still take the arbitrator's decision, and then we had to go to circuit court. Pardon me, on that one was probate. So we went to the probate court judge, and it's the probate court judge that gives the rubber stamp approval, usually, unless the other party objects to it or claims some type of undue influence on the arbitrator, which is very rare, very rare. Okay. So, you know, do I like arbitration clauses? I like them because they do make the process a lot faster. Do you have, you know, some type of favoritism towards a contractor? I think that most good arbitrators are doing their, you know, I know it's hard for the general public to believe this, but most people want to do their job and want to be fair. An arbitrator also has incentive to be fair, because guess what? If he's not fair and he's going to, you know, prefer one party over another and be prejudiced by just the fact that you're, you know, dealing with a contractor, well, they're not going to be hired again.
Right.
Right. And some people make arbitration their whole living. So I personally have never had an issue with any arbitrator in 30 some odd years. Okay. But I have heard stories. In this situation, can I tell you something, Blair? In all situations, it's always best for the parties to resolve their differences without a third party decision maker. Now, yes. I know that we're going a little, you know, we always kind of go a little bit down a rabbit hole. The one thing is you really have to have an attorney look at your documentation before you sign, because a good attorney could put in there, look, before you go to arbitration, the parties will agree to mediate. Well, mediation is going to be less expensive than arbitration, and it's a process first that is you know, required before you can get to the more expensive process, more involved process, right? So you require it. I put that in almost all, unless my client says, no, I don't, I just want to go right to arbitration if we have an issue. But for the most part, I will put a mediation clause in there that the parties have to mediate before they go to arbitration.
Okay. So the mediation is like an opportunity to resolve it even faster for even less expense before even having to go to arbitration. Okay.
Right. And mediation usually is not going to be binding. It's going to be, you know, any decision and settlement is going to come voluntarily between the parties. Arbitration is more or less like an enforcement, right?
Sure. Okay.
Great question, though.
Yeah. No, that was a good question, and I think so. That was, you know, when we first started using contractors for our properties. That was something that made us raise our eyebrows, but it's just because we didn't really understand it, you know. In our mind, everything went to court, and if you're trying to bypass getting in front of a judge, there must be something fishy there. But anyway,
let me tell you what, Blair, before we go to the other question, as expensive as it is for perhaps a homeowner, it's going to be just as expensive for a contractor. Right? They don't want to spend the money on an attorney and have to go. So it's incumbent on both parties to try and get things resolved. And, you know, I think, you know, mediation at the very least is a good place to start.
All right.
You know? Okay. Good question.
Good question. Good answer. Thank you from Frustrated in Benton.
Right.